Good evening, mediators. Welcome for our evening session this evening. We just have a few minutes as we hold on a little bit for the speaker. But yes, do feel at home. We have had a good day so far in the symposium, and we're looking forward to a good closing with this particular session. Okay. Thank you very much, everyone. I think we are ready to get going. We have Honorable Wanjala has joined us, who will be our speaker for today. So we will start, as we normally do, with the national anthem. And then we will be able to give some housekeeping tips, and then we'll be able to proceed. So we'll do the national anthem in English. O God of all creation, bless this our land and nation. Justice be our shield and defender. May we dwell in unity, peace and liberty. Plenty be found within our borders. Okay, so once again, mediators, I would like to welcome everybody for this evening session. We have had different sessions from the morning, and we just had the afternoon session looking at the Singapore Convention and the opportunities that that opens for us as mediators. We will have a speaker during this particular session who will be taking us through the issue of family wealth mediation and looking at whether succession is a success within Kenya. As we go through the session, as the speaker is going on, I encourage you to get engaged through the chat facility. You can key in your questions. You can be able to key in your comments. And I think we'll go right away to be able to start that. Our speaker for this evening, who will be closing for us as well, is Honorable Moses Wanjala. A little bit about him. I believe many of us, most of us perhaps have encountered him. He is a senior resident magistrate and he serves at the Milimani courts or the Thika courts sometimes as well. He's also the registrar of the MAC, which is the Mediation Accreditation Committee. Honorable Wanjala has been trained in mediation several times, both locally and internationally, and he is a chartered mediator. He will be taking us through the session that explains some of the issues in succession, which is good for us, which is one of the pathways that we can follow as mediators. Which is one of the pathways that we can be able to follow as mediators. What we have been able to look at so far today, in the morning we were able to have a discussion on education and the disruption that is in the education field and the opportunity that presents for mediation. After that, we're able to look at the labor sector and employment laws and what we can be able to do as mediators within that particular field. After that, we also had a session looking at extractives and trying to understand what is there in mining, and being able to also identify what are some of the opportunities that we have as mediators. And just this afternoon, we have had a look at the Singapore Convention. So as we've finished up today, this afternoon, we will have Honorable Wanjala take us through family wealth mediation, and then after that, he will also be able to take us through the court annex mediation session, mediation program, and be able to answer our queries. So I will go on to invite him to just go ahead. Honorable Wanjala, I don't seem to see him. He seems to have gone off, but not a problem. We will just sort that out. As we figure that out a little bit, I will invite Nyamato to be able to give us, just highlight some of the things that we have been able to pick out as mediators from the session that we have had today, as I just tried to get Wanjala back on. So Gibson, kindly, you could just be able to.
Thank you, Sarah.
Yes, you're welcome.
Can you get me okay?
Yes.
Thank you, Sarah, for opportunity once again to. So I didn't quite fully attend the last session, but I can just see what I was able to pick. And I guess most of the people here also attended, and they were able to hear one or two things which maybe I didn't hear or what I had also. But basically what I heard from the Singapore Convention is that we are at a good standing. We should be looking forward to better days in future, in that the NCI is working so hard to put things together, to start accrediting mediators, their panel, which process we've been told on how to do. We also told of the process by which they're trying to come up with a policy, which is also another very good thing for us as mediators, because the ADR policy will be knowing the specifics on how we will be able to engage, whether locally or internationally, something which a station like Kenya will need, because we want to set up, or we want to stand out as people who are serious with mediation and ADR, with a policy coming in place, and then of course with the Arbitration Act in place, and then also if eventually Kenya ratifies and accedes to the Singapore Convention, we will be standing at a better pedestal in terms of us being recognized as international mediators. We will also be standing at a better pedestal in terms of not having so many challenges as to recognition of mediation and other ADR practices. So we don't have challenges of people trying to wonder what is the use of this mediation if the agreement cannot be recognized. And then there is the aspect of the Singapore Convention itself bringing impetus into ADR, into mediation, into mediations, in that it gave them credibility to the level of an award, which is given in an arbitration. So those are the positives which we should be counting on. There are also gray areas which we should be looking at trying to mitigate, like lobbying so that we have Kenya accede to the Singapore Convention. There is also something which Lawrence Ngugi also pointed out, is that they are also working on having synergies across the other centers of arbitration, in that once you have been certified locally, that is in Kenya, you don't also need to run around and get certified in other jurisdictions. For example, in Singapore, could it be Hong Kong or Taiwan, or could it be your client is having an issue down in Kigali? And that is something we discussed some weeks back, that we need to make Kenya center, a serious center for mediation already, and clearly we are on the right path. We have the right people in place. All we need is to have the effort being put, and we hope that everything is going to work out well, which I'm inviting all the mediators in this panel, that the fact that we've been able to pull together this far, the fact that the government has given into some ground, has ceded some ground in terms of recognizing mediation. What is left is really not much. It's also to push further and have mediation being recognized in terms of having the government accede to the Singapore Convention for purposes of the international outlook. Lawrence also did point out that the fact that the government has not acceded to the Singapore Convention does not mean mediation locally stops. Remember, it's in our interest that we have mediation to be a very robust department, or a very robust scenario in the local scenes. The discussion we're just about to have with Honorable Wanjala, I hope we'll be picking into what it is that is happening with the court annexed mediation, since he's the head. Now, if we can be able to impress that, if our judiciary can be able to impress that a little more, especially around this time of COVID-19, if we could extend the level of engagement in terms of online mediations. So the other day, the judiciary had professing that they have been able to unlock disputes, family disputes, which were stuck in the courts for so long. Then these disputes have been resolved to a level of 7,000 cases, and that is a positive. If we could enhance it further, then we could really be in a good place. Thank you so much. That's all I could say for now. And Sarah,
okay. Thank you very much, Gibson, for the overview that you have been able to give us. Earlier on, Honorable Wanjala, we had just introduced you. Sorry about the technical hiccup that you faced, but we are looking forward to you speaking to us on the issue of succession. And probably just as you go into your talk, I would request that I think one of the things that I pointed out in introducing you is that you have done, you have had trainings in mediation in different places. So maybe just as you go into your talk, tell us just in a sentence or two, what actually is a good mediation program? What do you consider to be nice when we're doing a mediation program? What would be something to think about as having a good mediation program? And then you can go right off with your talk. Karibu sana. I think we are not able to hear you. Honorable Wanjala, I think we are not able to hear you. Honorable Wanjala, can you hear me?
Hello?
Oh, yes, great. Thank you. We can hear you now. Thank you very much.
Okay, sorry for the lapse in the internet.
No problem.
I didn't anticipate that. I've just had a meeting a few minutes ago. Now, I didn't hear your introduction of myself. I'm hoping it was complete and that our viewers are able to know who they are speaking to. If I heard you well, your question was about a good mediation training program.
Yes.
Yeah, a good, of course, where we are headed right now, I would consider a good mediation program to be the one that, first of all, incorporates our own unique circumstances as Africans. We've had problems because most of the training institutions that we have and the training criteria that we use is imported from abroad, and it does not take into consideration our unique statistics, our unique attributes as Africans. Disputes sometimes tend to be localized in terms of how they manifest themselves. So that program should be able to take into account the unique attributes, the circumstances of the dispute, the community where the dispute arose, and be able to offer a local solution. That's why I'm not really a very big fan of a training where most of the trainers or almost all of them are from abroad.
Okay.
Because it then misses out on the local Turkana, for example. It will take a different dimension if the same dispute were to occur in Lamu or in Malindi. So a good program is the one that takes into account those peculiar. Also, where we are headed, how do we modernize our dispute resolution mechanism in terms of mediation? How do we harness on technology, for example? How do we ensure, for example, that our mediators are better equipped than yesterday's mediators in handling the disputes that arise? So that training that incorporates the future in terms of technology, in terms of the modernization aspect of it, and that takes into account the mutating nature of our disputes is one that I will go for. So first of all, we look back. What is the nature of the community? What is the environment and setup of that dispute? Where are my trained people going to work? So that your training enables them to take into account all that. Then you look at the future. Am I equipping them for the future? Am I taking into account all the social dynamism that may take place with regard to dispute resolution 10 years, 20 years or so? Yeah, so those are the main things that I look at right now.
Okay, yes, thank you very much for that overview. Good insight for us as mediators, even as we choose programs. So the session that we are having this evening, and which Honorable Wanjala will take us through, is the session on family wealth mediation. And he will be helping us look at the issue of succession in Kenya to be able to explore whether this is a success, and to be able to share with us perspectives from the judiciary. After that, we will have some interactive session, and then we will be able to move on to his other role as the MAC registrar, and we will be able to handle any questions that we might have in that particular area. So Karibu sana, Honorable Wanjala, to speak to us on the area of family wealth mediation.
Thank you, Sarah, and thank you for those who are participating in this. My apologies that some of the minutes have been taken away by some technical hitch. I'm hoping that we'll be able to cover as much as we expected. Now, there is a lot happening in family mediation, and family mediation involves disputes in families, but this particular talk focuses on family wealth. When I was invited to talk about family wealth, first of all, I was wondering why the organizers chose on family wealth and not family property. Because wealth has different connotations. There are people who think that wealth is how much that someone has. When you talk about family wealth, people really tend to look at the material possessions of a family. They tend to look at what are the financial implications when there is a dispute that arises in respect to the properties that a family owns. But the family setup that we have in Kenya right now, when you talk about family wealth, right now you go beyond the materialism of the family, and you look at even the human capital of the family. You look at the social capital of the family. So a family setup right now is much more different than what people used to look at in the 10 or 15 years ago. So my talk today will really focus on the economic wealth of a family, not necessarily the human and social aspects of it, and the disputes that arise therefrom, where we are as a court and how we view them, how we handle them, and where my viewers can come in as trained mediators to help resolve this. Now, when you talk about family wealth, it may be tangible or intangible assets that our family owns. The tangible assets are the ones that you see and the ones that you can attribute a particular economic dimension to it. How many cars, how many heads of cattle that our family owns, parcels of land that our family owns. But there could also be the intangible one, including things, for example, the intellectual properties of a family, the family reputation, family values, and so on. So when you look at disputes that arise from family wealth, you need to open up your mind and look at so many things that accompany that. People tend to confuse between family properties and matrimonial properties. And I think that is a good point to begin with. Matrimonial property will essentially entail the property owned by the spouses, the husband and the wife. When you talk about a family, of course, you are talking about the children and you're talking about other people that make up the family. So if there is property that is tied to that family and there is a dispute that arises out of that, how do you resolve it? For the sake of us as mediators, I would prefer that we deal both with the matrimonial property and family property, because the disputes that arise therefrom tend to be intertwined. The disputes may arise during the lifetime of the family members. Disputes may arise after the death of any of the family members, especially the spouses. In our courts right now, we have so many disputes. Some of them do not, so many cases, sorry, but some of them do not necessarily involve a dispute. Some of them may just, someone may come to court just seeking declaratory orders. For example, if you are a spouse and you would want the court to declare that you own, that there is you own certain property, or that a declaration that certain property forms a matrimonial property, probably a dispute will not have arisen. Now, if we talk about succession, our law requires that once someone passes on, you have to file a case in court. Whether you had a will or not, someone has to file a case in court so that they are given that authority or that power to administer that person's property. If there is no dispute as to the distribution or the rightful heirs of that person's estate, then probably that will not go to hearing or will not go to mediation, because it's not a dispute. But the problem we have right now is a majority of the cases that ends up in court, either as a family dispute or either as a family case or a succession case, will eventually end up in a dispute. So that if, for example, someone had a will written before his or her death, then he had specified the property that he or she had. He had specified who are the beneficiaries, how each one of them will get their own share, and how and who the executor of that will is, and how they will be able to distribute that property. But if that will was to come to court today, the court will have to ascertain whether it is a proper will or not. The court will have to ascertain whether it is a valid will or not. Now, in that process, the court will look at how the will was drawn, how the property was distributed. Was there any beneficiary who was not adequately provided for or not? If the court was to find that the will is valid, and it will definitely give effect to the wishes of the deceased. So it will distribute that property in accordance to the provisions of that will. But most often in our courts, we find that there is a dispute. Someone will always show up and say that that is not a will that was made by my late father or mother. We've heard about those cases. Someone will always say that I was not appropriately provided for. So if we end up at that point, then that will have to be invalidated by the court, and we'll go back to square one, where the court now has to look at the properties of the estate, then look at the beneficiaries of the estate, and then find out how it can distribute that. That is when now it becomes a court case. That is when it becomes a dispute, because everyone has the desire to own much more than the other. Our dynamics as an African society is that we don't really write wills. That is not really the culture of many Kenyans. So a majority of the succession cases that we have in our courts today are what we call intestate, where someone has to come to court to seek to be given permission to distribute the assets of a deceased person because there is no will. Eventually, that will lead to a dispute because most family members are not able to agree. And that is a sad situation, because you would expect that family members are able to look at what properties they have and who is in much more need than the other, and so that they can, are you getting me? So that they can be able, okay, thank you. So that they can be able to distribute that property. So that us as courts, we are reduced into looking at how a particular family should be able to share whatever a deceased person left behind. Of course, that is not the best way to go about it, but sadly, that is the situation that we have right now. So that there are so many court cases. If I can just look at the statistics, for example, in the family division, last year alone, that is the family division at Milimani, a total of 2,452 cases were filed, succession cases. 4,435 were resolved, and we still had 1,276 pending. So that you've heard that there are families that take up to even 30 years in court trying to resolve a succession dispute. Much of it has been contributed by the nature of the law that we have. Our law, the law that we use right now, is the law of succession that was enacted in 1982. There were recent amendments, I think last month or so, but it didn't really cover a lot. And that law has some loopholes in terms of coming into accord with our customs and our values as an African society. So in an African society, you look at, for example, issues of marriage, you look at issues of customary trust, for example. There are cases where in most African setups in Kenya, when land adjudication was being done after independence, in most cases, the land will be registered in the name of the eldest son. Now, the law would recognize that that is the rightful owner of that parcel of land. But then, eventually, when the case comes to court, the court has to decide whether that person was registered as absolute owner or on behalf of other people. So it becomes a dispute, and the court has to sit down and look at it so that it is able to distribute the property fairly amongst all the beneficiaries of a deceased person. There are quite a number of laws that deal with succession in the country. You look at, because as a family dispute, then it brings in so many other dimensions in terms of child maintenance, in terms of who are the validly married wives of the deceased person or not. You look at the provisions of the Land Act. Because of our law of succession, if I may just pick one example, it says that upon the death of the man, all the wives and former wives of a deceased person are recognized as beneficiaries. So how do you treat someone who left and then got married elsewhere and then comes upon the death of this person, and they will want to take part in the estate of a deceased person? They will also want to inherit something. So those are the dynamics of family property, family wealth. When we look at succession, it has a lot to do with our law. It has a lot to do with our culture, and it has a lot to do with where we are as a country right now. If I may just proceed, I hope that my sound is okay.
Mm-hmm.
Yeah. Yes. Where do we come in as mediators? Because I've just given you statistics, and the ones I gave you are for just one division in the whole one division of the High Court in the whole country. Succession cases are filed in all courts across the country, and the numbers are very high. Right now, our pending cases in court as a country is over 500,000, over 500,000 cases. And a majority of them are succession cases. A lot of property held in, and a lot of acrimony that these family members are exposed to. Of course, we do not desire as judicial officers to be making a decision that is binding on the family members. If you decide that Party A will get 10,000 shillings at the exclusion of Party B, probably you have thrown a wedge between those people. If they are brothers, they will not live in harmony there after your judgment. So we would wish that almost, if not all, of succession cases are resolved through mediation, because we know of the benefits of mediation. But then if you come in as a mediator, I would like to point out the following. Succession cases are very contentious. They are very, very contentious. In fact, in my own experience as a judicial officer, they are the cases that I will say they have been very contentious when you hear parties before you, and when you make a judgment, you really feel like you have not helped these people. They are highly emotive. There are emotions running amongst the family members, because they come to court and they would want to know what is in for them. So as a mediator, you would want to look at the emotions of the parties that I am dealing with. Some of them are brothers, some of them are sisters. You wouldn't want to be the one separating them further, because their late father or mother has left property for them, which is supposed to be a unifying factor and not one that divides them. You will also be concerned with the preservation of the relationship that these people already had. When we started court annexed mediation in 2016, we picked on two divisions, that is the family division and the commercial division. In commercial division, we were looking at the commercial relationship of parties. Sometimes those are just two people, a businessman and one businessman and the other. If they are not able to resolve their dispute, probably one of them will be able to get another business partner and continue with the relationship. But you cannot be able to repair, you cannot get another brother, you cannot get another sister. So as a mediator, you will be so much concerned as to the preservation of the relationship that these people have. Their issues at that time are so much intertwined. Probably it may be involved with a divorce. It may be involved with child maintenance. It may even involve domestic violence. So as a mediator, you look at the emotions of these people and you would want to bring them together at the end of the dispute, so much more than you would even do in a commercial dispute. The other thing, as a mediator, you will look out for is that family succession disputes involve so many parties. I've had cases where a whole family comes to court, over 30 people, and they are the only ones filling up the court in one case. So it is difficult for those of you who have already handled a succession dispute. You'll agree with me that there is no single dispute you will have where you only have 2 people in the room. So it becomes much more overwhelming for you as a mediator to deal with more than 10, 15, or 30 people at one time. But you have to look at all of them. You have to look at their interests. You have to ensure that you are trying to help them the best way you can. The other thing you may need to look at is that if you do not help these people come together, you are wreaking havoc in the societal brand of the family, of the society, the strand that holds the society together. Because a family is the basic unit of a society, and then thereafter the country. Like I said before, if a business person is not able to agree with the other, they can always move on and get another person and deal with. But if a family is broken down right in the middle, and another family and another one, the society will be broken down and eventually will not have a country. So you really have to ensure that the family holds together even after beyond that dispute. So when you look at that, the other thing, of course, is the level of education. In this country, majority of the people are not so much educated. Their level of understanding, probably in terms of the dispute, there could even be language barriers during your mediation. So you may have to calm down. We've had situations where people from different parts even have to log into the local language to be able to assist these people. So there will automatically be language barriers when there are so many parties, and most of them are not educated. And of course, finally, you look at the nature of the dispute as intertwined with the cultures of that particular community. I say so because our law of succession most of the provisions were borrowed from the English law. Whether they were applicable to our society or not is another dimension altogether. But we've faced a lot of difficulties because we try to apply foreign law, and yet what demands of us is to look at the culture of the culture where that dispute arose or where that family comes from. Are we supposed to abandon culture altogether? Sometimes the law has done that. I can pick an example of the Constitution, and this is an example that came to me when we were doing a sensitization on matrimonial property rules. The Constitution recognizes that marriage is a union between people of opposite sex. So if there is a union between people of the same gender, the law will not recognize that as a marriage. But the reality on the ground is that there are so many societies that still recognize same gender marriages because of our culture. For those of you who know about the Kalenjin, I think there's something they call a toloita, something like that, where a woman is able to, if she has not been able to sire children, then she can get another woman who will be able to sire children that she will call her own. When we were doing that sensitization, we went to Machakos and we were introduced to a culture they call Iweto, where a woman is similarly able to marry another woman so that they can sire children for them. That discussion was so agitated because the person who introduced that was a chief. And he said that when those disputes come to court, the court says that that is not a marriage for legal purposes. But those disputes come to them as chiefs. And he gave an example where there was a lady who was married to a certain man. They had children. All of them were girls, I think 3 of them. Then the man passed away. So because she wanted to carry on the lineage of that male, so she was able to bring them up on the same property that they had with the husband. And later on, I think the lady also passed away. So these 2 sons that had come in with the second woman wanted to, they had filed for succession. But the girls of the former man came back and said that this is our father's property. You cannot inherit it. So it was a dispute that the chief was struggling to deal with it, because the second marriage that involved 2 ladies is not recognized in law. But then there are children who have been brought up, that is the home, the only home they know about, and they want to inherit. So if we were to hold that that was not a marriage, where will these 2 sons go? Which property will they inherit? And how do you cater for that as a court? So if such a dispute were to come before me sitting as a judicial officer, of course I will hold that under the law, the second union was not a marriage, so these are not children of that union, and therefore they cannot inherit. But then on the ground, it would be very difficult for these daughters to come back and displace their, I would call their brothers. So those peculiar things that come in, and the one I've talked about, customary trust, then are issues that play around before you as a mediator, because the court cannot use the law to resolve it. So as a mediator, when a case comes to you that involves succession, those are some of the things that the dynamics that you'll be able to look at and be able to see whether you can help these people. For the courts, we've been really trying to ensure that most families go home happy. I don't know whether you introduced me as that as such, but when I sit at Thika Law Courts as a judicial officer and a succession case comes before me, I would hope that it takes the first avenue where there is no dispute. Then you are happy that you can give authority to one of the people to go and distribute that property without dividing the family further. But where a dispute arises and a sibling takes on another sibling because of property, it becomes very sad. I remember one of the cases where I really gave chances to those people to go back and see whether they could resolve. And it was it was challenging for me because they were not able to resolve. And eventually I had to write a judgment. What we have in our societies, in our most of our families in Kenya and the communities is really patrilineal. You will see a situation where most of the property is allocated to the sons. They have developed that property, they have constructed a house, they have planted coffee bushes, or they have planted tea. And then now their sister, who was married so many years back, comes back and wants a share because the law of succession and our constitution recognizes that they have to share. Now, if you split that property in accordance with the law of succession, then it will automatically lead into disputes, because someone may be forced to go and uproot some of the tea or coffee bushes so that they can accommodate their sister. So I kept on giving a chance to these people to go back and see whether they could talk and see how they can resolve it as a family, but unfortunately, they were not able to. But those are the dynamics you can see, because these people in law, the ladies in law, have a right to inherit. But then in practice, they have come back, they are married elsewhere, when we were doing the sensitization in, I think it was in Nyeri, we came across another example where someone said that if I give to my sister a share and she comes there and she builds a house and she comes with her children and she was married in Kisii, then we will be having in our land people who are not of our own tribe sharing what our father left to us. And obviously you can see how much acrimonious that can turn out to be. Those are just some of the things I was saying, that our law is silent or it has some lacunas. And therefore, those people who come to us hoping that they will get a solution that fits them, that helps them as a family, might be disappointed. So we really encourage them to try mediation. We refer a lot of cases to succession cases to mediation. And it is an area that I think if us as mediators will take on, then we can be able to help our family and our society. Because like I said, if there is a dispute that divides a family, then it divides the society and then it divides the whole country. I hope I've exhausted but some of the things that people that you would have expected that I talk about, but I'm glad to also take on questions if there is an area that I've not covered. Thank you.
Okay, thank you very much, Honorable Wanjala, for a very good overview of how the matters are and the reality that you face while in the courts. I will just give an opportunity to Lily Minor. To be able to give a commentary, and then also open it up for anybody who might be able to have any questions. So Lily.
Thank you so much, Honorable Wanjala, for that insightful discussion on family wealth. And I have been able to capture some of the things that I actually had in mind as you are talking. For instance, when it comes to culture and policy in Kenya, I observed that whereas the Constitution actually prohibits discrimination on whatever basis, such as gender, the same Constitution also allows for the application of customary laws in matters of personal law, such as succession. And whereas these two come into play, we find that some customary practices, inheritance practices, still favor males over females. So such lacuna and inconsistencies in the law and lack of a clear legal reform continue to hinder dissemination of justice. And I think this is an avenue for mediators to actually take it up, because in such instances, when mediators come in, they try to help in settling the disputes, and the parties, the disputants, actually settle their issues and come to an agreement. So I think that was really eye-opening. I was also asked to give an overview of societal, political, probably economic, and the legal aspect. Because I've mentioned about policy, I'll just go directly to the societal aspect of it. And one of the things that I came to think about while you were taking us through the discussion was that I recently saw one of the big tier firms observing high rates of wills being reviewed during this COVID period. And they are actually asking, so what's next after COVID? Is there a possibility where in such wills we could consider clauses that actually suggest mediation? That is something that I thought when I saw that they're actually reviewing their their wills. Most of the people are reviewing those. Maybe this is something we could think about as well as mediators. Still, when we look at our society, well, still women are still being discriminated on in succession matters, which is so unfortunate. And yet, okay, I meant to say that dispute resolution, according to a certain study by Hill, the Innovative Justice platform, they were saying that most of the dispute resolutions that are done informally are by chiefs and church elders. So I think there's also importance of sensitizing the locals about these matters of succession and trying to push for those people who they run to actually, for them to embrace mediation. So mediators still have a shot at ensuring that justice is also disseminated in these spheres. When it comes to political aspects, I was thinking about the patriarchy ideology that is unfortunately still being upheld, because when you look at what happens in society, sometimes it's propelled by what is happening politically. So where women are being sidelined in whichever aspect, you find they are still being sidelined even in succession matters. When it comes to the economic aspect, I think there has been a success somewhat in succession matters, because since the law was reformed to allow women to inherit whether married or not, this has actually empowered women, and this has enhanced financial inclusivity in the society when it comes to the economy. So I think in those terms, when you look at succession, financial inclusivity has been enhanced where women are also being empowered. When it comes to the legal aspect, I think I've mentioned it when I was talking about the policies that we have and the inconsistencies in application of the law and lack of proper legal reform is still haunting us as the Kenyan society when it comes to succession, because of those differences. When we say, let's apply our customary laws, at the same time, we're saying, do not discriminate. At the same time, being discriminated. So I think those are some of the things we can actually look at and see where there are some gaps and lacunas, and probably with the help of our judicial officers as well, in trying to really push for the mediation agenda. And especially, it's actually encouraging to see judicial officers who are also mediators. They really help in pushing our agenda forward. So I think that is what I had gathered and what I had taken home from the discussion by Honorable Wanjala. Thank you. Back to you.
Okay. Thank you, Lily,
Yes.
for what you have shared. We do have some feedback in the comment section, and I will just read through it, and then request Honorable Wanjala to be able to just address some of those issues. So Patricia Okech says that the talk is encouraging because it reassures her that it is okay to refer the case back if the parties do not agree. Then Andred asks, what happens when a parent leaves a written document signed by a brother and a witness, and one party does not respect that? So what happens when a will is left and one party does not respect that? Then Tabitha has a few questions. She asks if or where to be able to find documents on matrimonial property rules. Secondly, she gives a succession case mediation in a scenario where the late husband leaves 4 or 5 wives together with children, and decide that each family to appoint 2 or 3 members from each household to sit under a mediator. In the court scenario, all children must appear. Can a mediator accept their request? So, Honorable Wanjala, we request that you would be able to address those questions that we have. Kindly.
Thank you. Thank you. Thank you so much. I'll start with the comments before I come back to Lily. Now, on Tabitha, your first question is how we can avail to you documents on matrimonial property rules. We have a draft. I don't know whether you are told that I sit as the secretary to the Rules Committee of the Judiciary. The Rules Committee of the Judiciary is responsible for making rules of procedure. That includes matrimonial property rules. So as a committee, we worked on a draft of matrimonial property rules under the Matrimonial Property Act. There's a recent act that was made in 2015 to replace the one that we were using before. As a country, we were logged on to the Married Women Properties Act of 1886. Now, those rules, we were just about to conclude on sensitization and stakeholder engagement just before Corona hit us. So they are still in draft form. We still calling for comments from members of the public. I can share the draft so that you look at it, and if you have any comments, you can share with us so that we include before we forward them to the Attorney General for publication. So if Sarah will share my email or the email of the Rules Committee, then we can be able to get in touch so that we share the draft that we have with you. Now, your second question is with regard to, like I said, succession cases involve so many parties. Sometimes it may be almost a whole village, depending on how many people someone left behind. In law, everyone has to be heard, either personally or through the advocate, because you cannot speak on behalf of your brother. Here, people are competing. You want land that your brother has. You want land, and your brother also wants that particular parcel of land. So you cannot expect that your brother will speak on your behalf if they attend the mediation. That is very risky because eventually someone will say that my voice was not heard. So as a mediator, what I will encourage is that as much as possible, try to ensure that you get to hear all from all the parties who are beneficiaries under that estate. Because if a brother says, I have agreed, I will take 10 acres, and my brother who is not here will take 2 acres, then eventually that might give rise to some disputes. So unless if there is a written authority, although that is not within our law, as a mediator, try to ensure that you have contact of all the people who are entitled under that estate. And let me just point out, even in our court annexed mediation, you realize that the dispute in court might just be between 2 siblings. But then there are other siblings who are not part of the case. But when you are resolving that case as a mediator, if it is referred to you, it is prudent that you get in touch with all of them. Because if there are 2 brothers before you, and those are the parties in court, and they tell you that we have agreed to share this land equally, then later on, they left out a sister, then your decision might eventually be overturned. So ensure that you try as much as possible to hear the voice of each and every person who is entitled under the estate. From Rashid, I can see your comment. You said that there was a training in Kwale, and the trainers were from abroad. but they tried to incorporate the unique circumstances of the Mijikenda people and the Kamba communities in Kwale, so that they can learn on issues including child rights and so on. So I think that was good, because in any training, if you do not take into account the local dimensions and perspectives, then you are not properly equipping that mediator. So assuming those international trainers were not able to take that into account, then you wouldn't know what unique dimensions that disputes take in the Mijikenda community. So a good training, mediation training, must be able to take into account the local dimensions of disputes. Patricia, you say that it is okay to refer a parties back to court if they do not agree. We, of course, do not encourage our mediators to be quick in referring cases back to court. But if eventually you can't be able to help them agree, some of them, the only language they can hear is a court judgment. I've shared with you of a case that was before me, and I kept on giving chances to these parties 3 times, and they were not able to agree. So eventually, if you are not able to agree, then you can refer the case back to court. But give your best. Ensure that you've given opportunity to all the people there. You've given opportunity to their advocates, because sometimes it may just be out of lack of information that someone is not willing to participate. So ensure that you have given them enough chance, so that eventually if you refer it to court, then there is nothing more you could do as a mediator. Patrick, you talked about a will. Someone left behind a written document signed by one person, and then one of the parties does not respect that document. Like I said when I started, the law of succession in this country recognizes succession in only 2 ways. If you do not leave a will, and most of our people do not do that. I've heard that people fear writing wills because they will die if they write a will. Most people don't write wills. Then you have to file a case in court as one of the children or beneficiaries of that deceased person for you to be given authority to administer the estate. It is given in the nature of what is called letters of administration, a grant of letters of administration. If someone left behind, that is the first one is called intestate succession. If someone left behind a will, then the court will normally treat it as a tested succession, where you have left behind a document on how you would wish your property to be distributed. Now, the law has given attributes on how a will is supposed to be written. There are moments when you can't write a will. You cannot write a will in anticipation of death. For example, you are so sick, you know that you will die in the next 3 days. That will might be invalidated. If you write a will under compulsion, someone forced you, someone tricked you, and you've had this before, where wills were invalidated by the court. But even so, where there is a will, the executor in that will has to come to court, file what we call an application for a grant of probate, for the court to ascertain whether that will is valid or not. If it finds that it's not valid, it will cancel it and it will go back to intestate succession. If it finds that it is valid, then it will allow you to go ahead as an executor and distribute the property. So if one of the parties does not respect, then the best way here is to ask the person who was named as an executor to file an application in court and a succession case in court, asking that the court determines whether that will is valid or not. There are parameters that a will should take. The witnessing of the will must be done by at least 2 people who are not beneficiaries under that will. So those are some of the things that the court will look at. And if the court finds that the will is valid, it will enforce it unless that person who is not respecting it was not adequately provided for. But if they were adequately provided for, then the court will enforce that will. Thank you so much, Lily. You've talked about so many things about culture and so on. And I agree with you. Our law is very clear right now that inheritance is does not discriminate whether in terms of gender, so that whether you are a girl or a boy, whether you are married or not married, then you can't be discriminated in terms of inheritance. But when the dispute comes before you as a mediator, and let me warn this, because even as a mediator, you should ensure that the agreement that the parties conclude is not an illegal agreement. So if, for example, parties mediating before you, one of the parties says, I am married, I am adequately comfortable where I am not interested in getting anything from the estate, then that is okay, because you voluntarily do so. We hear that in court always, because it's not mandatory that you have to get something, but you have to be given that chance to get it. So the law, as a mediator, you have to look at the unique culture circumstances of those people, but ensure that the agreement is not illegal. Well, still there are variances in terms of the application of the law, even across our courts in the country. There are those that agree that people should share equally. There are those that don't agree in terms of culture. And that's why I said, when it comes before you as a mediator, you really have to look at so many aspects. The law of succession provides that if it is a polygamous marriage, 3 wives and a number of children, and the man passes on, and the parties are not able to agree on how to share the property. Once the court has found out what forms the total amount of the estate, it will divide it in terms of the units of the family. So that the first house, if it has 3 children and the spouse and their mother, that is counted to be 4 units. If the second house has 10 children and their mother, those are 11 units. If the third house has 2 children plus the mother, those are 3 units. So you put together 3 plus 4 plus 11, you get, if it is 20, then you divide the entire estate among those 20 units. So the family, the house with many children will of course get more because it has more children. But then when you divide individually, you'll get that each of the children has gotten the same share as the other. That's what the law provides. But then people are not normally so happy with that. So you look at it as a mediator, you look at all that. Wills being reviewed. I don't know whether you talked about wills in court or that are already in court, or wills that people are doing outside there. I would really be happy to see how, if someone would write a will and then choose the forum of resolution of a dispute where people do not agree with that will, because in contracts, people can choose that if a dispute arises, then it has to go to arbitration, for example, or to mediation. Then the court observes that. But in a will, it's not a contract. So the law of succession requires that you have to file a case in court. So the testator or the person who passes away cannot say that if there is a dispute with regard to my will, that it will not go to court, that it has to go to mediation straight away. That will still be illegal. But the way we are headed, I think we should reach a point where you can decide that if my family is not able to agree as I directed in my will, that they should just go to mediation right away. Then we may need a law reform. Discrimination against women, it's still there culturally, but the law does not provide for that. So you can still enforce your rights in court if your culture discriminates against you. There is need for a lot of sensitization, empowerment of women in terms of finances, and application of proper legal reforms, inclusivity, and so on. Those are things that you really need to look at as a mediator in terms of policy, in terms of the legislation, and then in terms of the culture where that dispute has arisen. I thank you, Sarah. Back to you. I don't know whether there are any other new comments here, but you can proceed to the next. Yes.
Yes, I think you have pretty much covered everything. I can see there's one more quick question from Tabitha. She says, in a court annex mediation, where parties agree and sign the agreement, then later one party does not follow the agreement resolutions. Kindly explain to us how this case is again handled by court. I ask this because these clients mostly go back to look for the mediator.
Sorry, could you please go back to it again? I didn't get you correctly.
Okay, so what Tabitha is asking is that sometimes during the mediation, then there is a settlement is reached and parties agree. However, after some time, one party does not follow through with the resolutions of the agreement. So Tabitha is requesting that you explain how this is handled in court, because she says that most of the time the clients look for the parties look for the mediator that handled the matter.
Thank you. That's the beauty of court annexed mediation, because you have an enforcement mechanism. And maybe when we're talking about the future of mediation, that's the problem that mediations conducted out of court have, because the biggest problem is enforcement. In court, once you sign the settlement agreement and it's adopted by the court, it becomes an order of the court. It has to be enforced as such. So you can't go back to it. You can't go back to the mediator seeking to wriggle yourself out of it. But if the mediation was concluded outside of the court framework, then enforcement has really been a challenge, because how do you treat that? Countries like Italy have moved on, and they do provide that once you agree and you sign, it can be enforced as any other contract, as any other agreement. You can actually enforce it as any other agreement. But here in Kenya, in court, under the court annexed mediation, once people sign the mediation agreement, settlement agreement, it becomes enforceable as any other court. You can actually execute it. But for mediation concluded outside, we really need law reform to ensure that probably, for example, those agreements can be filed in court and adopted and enforced the same way those ones are done under the court annexed mediation. So that is one of the things we really need to look at as the mediation fraternity, so that we also give impetus and a sense of trust for the mediations that are done out of the court. Otherwise, as things stand right now, if someone was to go back to his word, it will be challenging for the other person if the mediation was outside of the court. As a mediator, it depends on your training and the agreement that you had. Your work ceases when the mediation is finished, unless the parties in a new engagement maybe allowed you to help them in enforcing that agreement, which puts you in a tricky situation, depending on how the parties are willing to abide by that contract. Because once you are done and there's a settlement agreement, going back on it and seeing that people are abiding by it should really not be your role as a mediator. It will put you in a very tricky situation. Yes.
Okay, thank you very much. Maybe you could just clarify a little bit more, explaining a little bit more about how to go about when the mediation is done outside the court. What then can a mediator do to be able to, is there any mechanism that the mediator can be able to follow to make the settlement more solid?
Solid in terms of enforcement, or solid
yes.
in terms of
yes,
it not
in terms
being
of
watered?
enforcement.
In terms of enforcement.
Exactly.
In terms of being watertight, actually you should ensure that it is, because we should not leave situations where parties will be wondering what is it they agreed on. That can be very tricky. On enforceability, I've pointed this out to a group of mediators before. The current law that we have under the Civil Procedure Act recognizes that a mediation settlement agreement, that is reached out of the court framework, if it was concluded by a qualified mediator, it can be filed in court and enforced as an order of the court. Now, up to now, there is no single mediator or party who has ever utilized that section. I think it's section 59D, who has ever utilized that section to bring to court a settlement agreement that they concluded out of court and ask that the court recognizes it and adopts it and enforces it. But there is a law to that effect. Probably what we also don't have as the judiciary are rules on how that can be done. Do you file it as a case? Do you just forward the agreement by way of a letter? Who forwards that agreement? Is it one of the parties or is it the mediator? Because if a mediator was to do that and one of the parties says, I don't know that, I've never signed that document, then as a mediator, you are really put in an awkward situation. There was a time we were working on draft rules to give effect to that. Those ones, we didn't push through because we wanted that to be part of the court annexed mediation rules that we are now working on. Because we don't have mediation rules. We had court annexed pilot rules that came to an end in 2017. Thereafter, we adopted the practice directions, which we've been using up to now. But we are working on court annexed mediation rules, and part of it will include provisions on how to give effect to section 59D, so that it is clear to you as a mediator, after I've concluded a mediation outside of court and there is a settlement agreement, how can I present it to court so that it is adopted, it is recognized, and it is enforced where the parties to fail to live by it. So I've challenged people before to even just do it by way of a letter and see whether a judge will decline it and cite section 59D. Because unless that agreement is adopted and becomes an order of the court, it will be very difficult for you to enforce it outside there.
Okay.
Yes.
So thank you very much. And I think that just takes us into the next section where we request that you take us through the court annexed mediation program. Some overview of how it works, and then we will be able to see any questions that may be from the mediators. Thank you very much.
Now, thank you. Thank you so much, and you are very lively. The questions and the chats, I think, they show that people really have an interest. I really encourage you people to take up on that area of succession and generally family wealth mediation. Now, but of course, if you still have questions on succession, you can throw it at me. I'll be able to deal with it. On the issue of the court annexed mediation program, I hope all of you are aware that the court is right now running a program called Court Annexed Mediation. It's a program that started way back in 2016, precisely on 4th of April. It started off as a pilot in two divisions, that's the family and the commercial division. The pilot in Nairobi, the pilot ended in July 2017, and then it was then made permanent, so that we right now have been running that program all through. We have since rolled out to all the divisions in Nairobi, apart from the criminal division. We have also rolled out to court stations outside of Nairobi. Actually 12 court stations. We are in Mombasa, we are in Meru, in Embu, we are in Machakos, Eldoret, Kisumu, Nyeri, and Nakuru. Now, the program, when it is anchored under Section 1, Article 159 of the Constitution, which encourages the court to promote alternative forms of dispute resolution. It's also anchored under the Civil Procedure Act, Section 59. There were amendments that were done in 2012, several of them, including 59D that I've just talked about. And those amendments under the Civil Procedure Act created the Mediation Accreditation Committee. This is a committee that comprises of many representations from outside the judiciary. This committee is primarily tasked with the, I hope I'm still clear.
Yes, you are. Go on. Thank you very much. Yes, yes, you're very clear.
Hello, Sarah.
Yes, I can hear you. You're very clear. Yes.
Okay. Okay. So thank you. Thank you. Primarily, that committee deals with the accreditation of mediators, enforcement of a code of conduct against the mediators, the issue of training of mediators, and the issue of professional development. Everything grows into something bigger. When we started, we were fused together with what was happening at the court level. But most of you who are accredited by MAC, that's the Mediation Accreditation Committee, should be aware that by now, the programmatic level of it, that is what happens at the court level, is now being handled by a secretariat that is chaired by Honorable Kendagor, who is a deputy registrar in charge of that program. So we deal mainly with the accreditation of mediators at MAC. We develop a list of accredited mediators, and then we forward that list to the court. So at the court level, matters are screened, referred to mediation, and then settlement agreements are adopted. Issues of payment, of course, we are still working on it. But right now we have sort of tried to specialize so that issues dealing with the program level at the court level is done by the court annexed mediation program, which is housed at Milimani. But issues to do with accreditation of mediators is done by the Mediation Accreditation Committee, which is at the Supreme Court, room 35. We started off with a very small number in 2016. We have really grown over time. Right now, almost 5 years down the line, I was just checking the records. We are at 696 accredited mediators. We renew our accreditation annually. Right now, around about 50 mediators are not active because they have not renewed the accreditation. So if you don't renew your accreditation, we will render you inactive, meaning that you don't get cases from us. But for those who are active, there is a list that is on our judiciary website. We have been able to learn so much, and from where we are, we intend to now take ourselves to the next level. If Corona had not hit us, we were working on hiring a consultant with the help of IDLO. We were able to advertise, and we got applications, which we are currently working on. Probably we may be doing some interviews shortly. That consultant has a plate full of things that we want the committee to help the committee do. We want that consultant to help us develop a training criteria for mediators. We want that consultant to help us have a handbook on court annexed mediation. We want that consultant to help us on emerging issues in mediation. As you all know, we don't have a grasp as a committee on who trains and how they do the training. So many training institutions have proliferated recently. Of course, people say there are many, but when you look at other countries, I was looking at Italy, and again, I was able to note that they have over 200 training institutions that train mediators. But these training institutions have been accredited by the Ministry of Justice. So we want a handbook that can help us be able to interact with the trainers so that whatever they give to our mediators is able to meet our needs at the court annexed mediation program. Our list is general. The mediators list is general. Once you are accredited, it just indicates whether you are accredited for family, commercial, land matters, depending on your application. But there are several issues that I would want to point out. But maybe let me just categorize them into two, where we are headed right now as the Mediation Accreditation Committee and the Court Annexed Mediation Program in the judiciary as a whole. We want to look at, first of all, the outside, what people have said, mediations that are concluded outside. How do we give impetus to them? How do we encourage citizens to resolve disputes by mediation outside of the court regime? We are really want to focus on prejudicial mediation, so that before you come to court, have you been able to try mediation? So in that, there are several things that we look at on sensitization, because we realize that it is very key. There are many people who don't know that that mediation works and that there is a system called mediation. So if I differ with my brother, I run straight away to court because I don't know that mediation is there. The other thing we look at is stakeholder engagement, engaging with our stakeholders from outside in terms of those who provide training, those centers, mediation centers. I've had mediation centers before. We have groups like Wasilianahub, I can point to that work on mediation in different levels. How can we engage with them so that they encourage the society as a whole to embrace mediation without necessarily coming to court? We look at training of sector players, and this is not necessarily the trainers. How do we train, for example, the chiefs? Because they resolve so many disputes, so that they can be able to play an important role in helping parties resolve disputes before they come to court. How do we engage religious leaders? How do we engage with the youth, the elderly, the council of elders, so that they can know what mediation is, they can embrace it, and they can tell their folk about it. And lastly, on the issue of law reform, policy reform, and legislation, so that we can be able to enforce contracts, we can be able to enforce settlement agreements without a problem. I've just given an example of Italy, where if you resolve a mediation outside of court, and you sign a settlement agreement, it is treated as a contract. Someone can take you to court if you renege on it. In Italy also, they have what we call required mediation, where you have to first of all try mediation before you come to court, and be issued with a certificate. If you don't settle, you will come to court and provide a certificate indicating that you tried. If you settle, then well and good. So how can we do law reform, policy reform on so many things, so that we can promote mediations outside of court? Our role is to cut off as many disputes from court as possible and encourage peaceful coexistence of members of the society, so that we can free some time for judicial officers to deal with those cases that must come to court. Now, the other dimension is inward looking. How are we improving on court annexed mediation program so that we take ourselves to the next level? And I will talk about a few things here. One of the things is empowering and facilitating mediators. We would want to see how we can facilitate our mediators to make them a better service providers than they are right now. And that cannot be done without working in conjunction with mediation centers and mediation training institutions. So we want our mediators to be the best. As a committee, as the Mediation Accreditation Committee, we want everyone who is on our list to be empowered to better handle mediations that they are doing right now. The other thing we will look at is increasing participation. Right now, I think on the issue of screening files before referring them to mediation, we don't engage parties, we don't engage the mediator. So we refer a case to a mediator, and a mediator has to maybe write back and tell us, even though this file has been screened for mediation, I have looked through it and I don't think it is suitable for mediation. Or in the worst case scenario, they struggle with it, they spend a lot of time, but eventually it is not resolved because it was not a proper file for mediation. So how do we screen better? We need to make it a participatory process and see how we can engage the mediators and the parties as well. The other thing we've been looking at as a committee is the issue of reward and sanction. We want our mediators to be the best. those ones who are working, who are doing the best work, how can we recognize them and reward them? For those ones who are not doing well, how can we sanction them? How can we refer them to further training? How can we refer them to further gain experience in terms of mentorship? How can we align our young mediators to the experienced mediators so that they can earn the experience that they want or they need? So the issue of mentorship and the issue of reward and sanction is one of those terms of reference that consultant will be able to help us. That consultant should be able to help us on the issue of CPDs, continuous professional development, so that as a mediator, we would require you to do ABCD so that we know that you are up to date. You are not just relying on the notes that you are given in 2015 when you were first trained. The issue of professionalism of our mediators, we would want them to be more professional in how they handle their work, so that mediation and court annexed mediation, for that matter, is a profession that someone can really look at and see that they are doing the right thing. We'll look at issues of sensitization, issues of mediation weeks, issues of infrastructure. I do agree that we don't have the best infrastructure for mediation right now, but we are trying to institutionalize mediation right now. And I'm happy that the CJ has bought into this. Right now, we are working with the Directorate of Building Services so that any new courts that come up, they are designed to also take into account mediation. They can have rooms for mediation, they can have breakaway rooms, they can have boardrooms, they can have rooms where children can play as their parents are taking part in a mediation if it's a family, if it's a family mediation. So that is an engagement and an understanding that we have with that directorate and the Chief Justice. Of course, continuous engagement with stakeholders, mobilization of resources. We have a big shortage in terms of resources to pay mediators and resources to ensure that the program is running without hitches. And at that point, I would just like to point out that when we started, we didn't have a separate vote for payment of mediators. That's why payment of mediators has really been delaying, because we have, after the conclusion of the case, we have to do a requisition. It has to go to the Chief Registrar for approval. We have to look for a vote where we will charge that amount. But we've been trying and getting through. I was just checking and I was informed that we had a bill of around 26 million. About a week or two ago, 11 million was paid to some mediators, and we're still having a pending bill of around 15 million. But we're working around it and we'll ensure that that is paid. But at that point, that we'll have a vote of our own in the budget, where we can say this is set aside for payment of mediators, so that even payment cannot take beyond 30 days. Then that is when we will say that we are okay. The issue of law reform, I understand there is a law that was introduced in the Senate on an ADR bill. I hope you people gave your views on it, but it's still not yet gone through. We need to engage with our stakeholders. We wrote our memorandum as a judiciary so that law reform takes into account court annexed mediation, so that it's made to be part of the mainstream resolution of dispute in the judiciary. We want our mediators, we're also focusing on result-based. Of course, we understand that mediators do not necessarily force parties to resolve disputes. But also, how can you explain a situation where 10 cases are allocated to mediator A? He or she returns 8 or 9 settlements. Mediator B returns 0 settlements. Then you again allocate 10 cases the same. So you start wondering whether there's value for money. So if there is a problem, a mediator is struggling, we have tried to empower in terms of communication to ensure that we have separate emails, for example, for issues on payment, separate emails for presentation of applications and renewal of your application, so that you can be able to communicate with us, so that you also give us results, because we are happy when we see people returning successful settlements. Now, on the last two, and these are very critical, is online resolution of disputes in mediation and specialization. Like I said, our list is general. When we started, we wouldn't have insisted on specialization, but that is where we are headed. And that's one of the terms of reference that consultant will be helping us. How can a mediator be better equipped and specialize in a particular area? I understand that most of our mediators in this country really do facilitative mediation. But what we've talked about, the family wealth mediations, you may need to really come in and also help these parties. Do you understand the nature of the dispute? Can you carry out an evaluative mediation? How can you do that if you do not know anything about that dispute? I'm not saying that you have to be a trained business person for you to resolve a business dispute in mediation, but you may need to have some basic information so that you can understand that dispute. If you are doing an evaluative mediation, you can be able to generate some suggestions to the parties so that they can compare and see which one is good for them. So we will really be focusing on evaluative mediation, on specialization. And one of the things we're also working with the ICT department in the judiciary is to develop an online database of our mediators, where all your credentials are uploaded there. So if someone calls us and asks us that they want a mediator who can better handle this kind of dispute, they can just check on that and they can be able to know that this is a good mediator. Now, online resolution of dispute, that is not an option, especially with the issue of Corona. I was just checking with the team at Milimani, and I was told that the uptake of online or virtual mediations has not been there, because there are very few. Though they are trying, there are those who are trying. Even today, there was a virtual mediation that went on, and parties have agreed to again have a further meeting later on. So for those mediators who are accredited with us and are not trying that, you need to start looking at that, because that is where we should be headed. The judiciary has an ICT strategy on automation of court registry processes, on digitization of court proceedings, and on issue of ICT infrastructure. Right now, we have every judicial officer has a laptop or a computer. We are working on reliable internet and reliable power supply, so that each court has a backup generator, so that we are able to handle proceedings digitally. Now, if the judiciary had reached that point, and the challenge actually is resources, but we have a strategy in place, then even with the corona disease, court proceedings will be being undertaken right now virtually. What about mediation? If the judiciary is prepared, the other remaining parties are the mediator and the disputants. We really can't have a lot of control on the disputants in terms of reliable internet and electricity. But for the mediators, you need to take that up as a challenge and see to it that you specialize and you are better equipped to do online and virtual mediations, because that is the next step where we are going. So that consultant should be able to assist us to work around the issue of online mediation, and eventually we will see that those ones who don't specialize and those ones who are not better equipped to do that, they will be lagging behind. So we really encourage our mediators to look at all that. So those are some of the things we are looking at internally. And once we get the consultant on board and we have all these documents that I've talked about, then you realize that we are operating at a different level and probably applying different rules and leaving behind those who are still relying on the training that they had 10 years ago. So thank you. That's where we are. We have done quite a number of cases since we started. I was just looking at some of the statistics. And I was told cumulatively we have done 1,587 cases. The value of cases that have us now currently in mediation is in excess of 40 billion shillings, those that have been referred to mediation. Those ones that have come back with settlement agreement is 8.1 billion shillings. In succession cases, we have 256 cases that have settled successfully. I can point out the cases that where one of our mediators helped a long-standing dispute in Eldoret. And so many of you can remember it. It had taken over 20 years in court of a prominent family in this country. The settlement rate in Milimani is 47%, outside stations is 52%, but we hope to take it to 100% once we have everything in place. Thank you.
Okay.
Thank you, Sarah. Over to you, if I was clear.
Yes, you were very clear. Thank you very much. We appreciate giving us insights into how the whole system is operating and letting us know the way forward. I think many of us were probably not aware of those. We do have some questions within the chat section. I will just read them out and then we request that you be able to address them. So Barbara had a question about what is the best way to go on the mediation process where the government is part of the process and a representative from the OAJ is present but has no authority to bind the government. I can see some comment from Wangari saying that very grateful for your dedication and that we are honored to have you. Then Tabitha also asks, she appreciates that you are always ready and willing to attend to our issues whenever possible. Then she asks, we thank the judiciary for paying us, especially during this time of COVID-19. Some of us have forwarded many ETFs. How can we tell which matter has been paid and which has not been paid so that we avoid reforwarding an ETF which has already been paid? Once again, she's very grateful. Yes, and then Nyamato also comments and says that he's grateful for the insight and that the statistics look good. They're hoping for better days. More mediators are grateful. I can see Kipsang, Christine, and Susan Wendot also registering their appreciation. So kindly, if you could address the questions. Thank you.
Thank you, and I appreciate your positive comments. We are trying. We can't be where we are without your support. Especially when we started, it was really a voluntary on the part of our mediators, and we did not take that for granted. We've had a challenge where the government is part of is one of the parties, and most of the mediators who have been allocated such cases will agree with me that it is a challenge that is yet to be resolved, because the law that we have right now is that if a government institution is sued, the Attorney General appears on behalf of that institution. It is the Attorney General that files the defense. Now, the Attorney General has to get instructions from the instructing institution. If, for example, it's Kenya Pipeline, for example, it's the Ministry of Education. The Ministry of Education has to give the details of what they would want the Attorney General to include. The Attorney General cannot purport to settle that dispute without getting back to the instructing government institution or department, because they are the ones who are seized of that dispute and they are the ones who know the ramifications of entering into a settlement. So the Attorney General's hands are also tied. If they appear before you and they tell you that we need to also get back to the instructing institution to clarify with us, probably at this point, unless the law is changed, as a mediator, you may be called upon to give that room. Sometimes there is a letter from that ministry to the Attorney General probably giving them general power to settle the dispute. That will be easy. But if the Attorney General has to get back to the mother department or institution to get further instructions before they can settle, probably even by way of a call or by way of a letter, then those are one of the tricky situations that we are still just trying to grapple with. And as a mediator, you may have to give them that chance, but you need to track the progress. You need to get, if you are getting outside the 60 days, you need to get the deputy registrar concerned informed, so that you tell them that we are at this point, we are just about to settle, but we are waiting for instructions from the mother institution, so that you can be given more time. But it will be difficult for the Attorney General to just pen down on a settlement agreement without probably getting further instructions from the parent department. So that is a challenge. It's still a challenge, and probably there is need for further engagement with that office, the Attorney General's office, to see how that can then be fast-tracked. The same problem even happens with insurance matters. And you see, if my vehicle was to hit somebody, I will be sued as the defendant, but it's not me who will pay. It is the insurance company that will pay eventually. So if the matter is referred to mediation, I can go there and agree that I will pay you 10 million shillings. But then I have to forward that award to the insurance company to pay. How will the insurance pay if they were not part of the mediation? They were not part of the agreement to pay. So the same problem faces us in that area, and probably that's why we are not referring so many of those personal injury claims, because the insurance is not normally part of the mediation proceedings. But those are challenges that if they land before you as a mediator, you need to give some flexibility so that the person who will eventually be called upon to pay can give their consent that that agreement should be written, should be signed that way. Otherwise, you'll have a settlement agreement that will not be paid. On the issue of Tabitha, which matters have been paid and which ones have not been paid. We have a problem in the system of payment as a judiciary. When we get the EFT forms and all those claim forms that you file, if it is a court outside Nairobi, they will be received, and I encourage you to file in triplicate or more, so that you retain a copy of your settlement agreement, so that the deputy registrar will then forward them to Nairobi, because they are not being paid at the station level. When they are forwarded to Nairobi, they will still go through some screening procedure to ensure that we don't double pay, and then eventually they will be forwarded for processing. Now, the payment system does not indicate the specific matters paid, but we have your records. If you have concluded and submitted to us 10 EFTs, we know that Mediator A has 10 claims with us. If we pay 6, we know as per our records that we have paid 6, but we can't tell that the 6 is in respect of this or that case. That is that we are not yet there yet, so I cannot confirm to you that we will be able to say that it is case number 25 that was paid and not case number 26. But we have records cumulatively of how many you submitted and how many have been paid. Now, I said you keep a copy because sometimes we do receive complaints, people saying that they submitted, those forms were not forwarded to Nairobi, and I will ask them to forward a copy of what they had submitted, and they don't have a copy. Now, if you give them to a deputy registrar in Lamu, and they get lost somewhere, it will be difficult, because as in Nairobi, we will not be able to know whether you concluded that mediation. When we ask Lamu office, they don't know, because they have misplaced the records. When we ask you, you don't have a copy. It becomes difficult for us to assist you. So try to keep records of at least the submitted claims, so that when you call us directly in Nairobi, we can be able to counter check and tell you which ones we received and which ones we have not received, so that we can check with our officers out in the respective station. Thank you for Namato. The statistics are okay, and for all the other comments, we are trying, and we really count on support.
Okay. Thank you very much.
Yes,
I'll just yes, thank you very much. I'll just have a read through the other comments as well. So Kipsang says thank you for the information and updates, and she suggests that we get more public participation in the ICT and data input, so that we can create an information pack available to more Kenyans, as the solved matters are already unlocking a lot of funds. Then we have Joy Namachi says that it is encouraging to hear the MAC vision to promote prejudicial mediation. Indeed, the bulk of mediation is out there, and what is brought to the court is a small fraction. She asks if we know the timelines within which the judiciary is expecting to have the infrastructure in place, given that the judiciary is still at consultation stage. So maybe that is something that you'll respond to. Then David Njoroge says that the Court Annexed program has been very successful, and he thanks you very much as being a strong pillar of the Court Annexed program. And he says that the payment needs to be streamlined, particularly concerning the delays, and also that online mediation is very welcome. Shauri is very grateful for the information and insight. Diana is also very grateful for the information and insight. And Kipsang asks again, we need to invite more stakeholders in these online forums so that they can understand mediation and how it will help all parties involved in the dispute. Can we submit online via email? Can we submit the forms online, the EFT forms? Or she's asking if the EFT forms can be submitted online. So probably you can respond to that, and then we'll be able to say something about the virtual cocktail. Yes. Karibu sana.
Thank you, Kipsang. Yeah, thank you, Kipsang. On ICT, there are two parameters involved. First of all is the preparation of the judiciary in terms of digitization and infrastructure. Like I said, we have a digital strategy in place. What we don't have is the resources. But we have taken tremendous steps since 2012. Right now, most court stations have reliable internet. Most court stations, if not all, have computers and so on. But that's why right now, some judges are delivering judgments online. I told you all judicial officers have laptops, and there's airtime that is disbursed to them monthly. So, but there is also with the availability of resources, there is need to even go further beyond that. So, I would say for ICT, for online conducting of mediations, for ICT, on the ICT part, most court stations are now ready. Now, on the side of MAC, like I told you, we are anticipating to get a consultant from IDLO. This is something that we had started towards the end of last year. The advertisements went out end of last year. Applications have come in. Were it not for the situation that we are in right now, we would already have conducted interviews, and if you have a consultant on board, by September or the end of the year, we should have something in place in terms of a handbook, in terms of a manual, or in terms of something we can work with, just for purposes of giving guidance and guidelines on what we expect to happen if a mediation is being conducted online. But even without that handbook or without that guideline, like I said, there are mediations that are already taking place and there's one that took place today. Like I said, most of the things we've learned on the way. So if you are ready from your end, the judiciary is ready from this end. As to the parties, probably we may reach a point where we can host them as a court, because if we have the infrastructure in place, it is easy to host them from our place. But then that should not hinder the mediator working from the comfort of their offices, or if they are better equipped from there. So we are ready even right now. If you are ready from your end and there's a mediation you want to conduct virtually, and the parties are willing and able, you can go ahead, as long as you notify the respective deputy registrar. But once you have the guidelines in place, then it will be easy, or even for the parties to understand what it is that is involved in that. Because if you don't have guidelines in place, then you might run into issues for some cases where parties, especially if it's a succession cases involving so many people. So a few parties who are able to do that are doing it right now. But that does not, our lack of preparation on the MARC side in terms of the handbook and guidelines should not stop you from moving ahead. So ICT is something we are taking on a step at a day, a step at a go, but we are already somewhere where we can host you. We need, of course, more stakeholder engagement, Shauri, that I can't agree more, because without stakeholders, there is nothing you can do. EFT forms, we are, during this COVID-19 pandemic, we really encourage everything to be online. You don't have to travel all the way to the court station to submit them. You can get in touch with the respective DR, you can get their emails, then you can submit those forms online. I don't think there should be a problem, and you don't have to travel to deliver them. So thank you. I think those were the only questions, and the other ones were comments. Thank you.
Okay. Yes, thank you very much. We really appreciate your insights and the information that you have been able to share with us. I think we are pretty much heading to a close, wrapping up the session that we have had. We have had mediators from different parts of the country, and I'll just give an opportunity to Stella to be able to say hello. Stella, would you like to introduce yourself and say where you have been participating from?
Hello, can you hear me?
Yes, we can. Yes.
Yeah, my name is
Stella.
Stella.
How are you?
I'm fine, Honorable Wanjala. I'm in Elre.
Thank you.
Yes, but I'm very, very
Yes.
grateful indeed. I've really learned a lot, Honorable. And I concur with my
You're
colleagues
welcome.
that we have more of this so that we learn more.
Okay.
Thank you.
Okay.
I certainly agree.
Yes. Okay. Thank you very much, Stella. I just I gave her an opportunity because I know she is from very far. I know there are mediators participating from quite a number from Nairobi and some of us from here in Mombasa. I'll just give Diana an opportunity to be able to wrap up the session. Diana, just some points and give a vote of thanks to our speaker. Diana, kindly.
Oh, good evening.
Good evening.
Thank you very much, Atara, for this wonderful moderation session. I want to thank you so much, Honorable Wanjala, for this mind-provoking, actually thought-provoking, mind-boggling session. Very insightful, giving us so much hope as mediators, telling us about how you're all ready for us. So we should be, if we are ready, you're ready for us. Also the fact that we should be better equipped as online mediators, especially at this time, that has given us, that now we have the opportunity to work as mediators online. Most of all, thank you also for your time. Thank you for everything that you've taken us through. As we've seen through the comments from the other mediators in the group, thank you so much. We really thank you for your time. Thank you for this nice evening. And Wangari, thank you for this great symposium. We are so grateful. And great mediators, we press on and go on, follow on, because this is a great opportunity. And thank you for having you, Honorable Wanjala. Thank you so, so much. Have a great evening, sir. Thank you. Thank you. Over to you, Etta. Thank you.
Okay. Thank you, Diana. We'll just have Wangari. Wangari, are you on? She'll just come on and, are you there, Wangari?
Ladies and gentlemen, thank you very much to our moderator, Mediator Sarah. It has been truly a symposium day and a half, and it's been such a delight to be running on with you. Honorable Wanjala, we are truly honored. You're just as your, probably your ID, Honorable. We are the ones who are truly honored to have had spent this closing session for actually Kenya's first virtual symposium day with you. We do not take it for granted. And the reason I say we do not take it for granted is because these are such unique times and there is need for giving hope. We have been running these sessions ever since it was declared in Kenya that we have the micro lockdowns, and so a lot of what we knew as the regular of society was not happening. We have been having these virtual sessions, and I encourage any of the mediators who may be on the call and even your colleagues who are missing out, then you're really missing out a lot. We hold, in the month of May, we've held virtual webinars with our advisor for this month, who is Gibson Yamato. And we've been going through various areas of possible areas of mediation, even post-COVID, coming from the theme of the Kenya COVID-19 Mediation Initiative platform. So we encourage mediators, let's engage in conversation, because it helps us then to shape where are we seeing mediation going, what is getting out, and probably what is coming in. And that really makes the theme for today's session very relevant, which is a focus on ADR tomorrow. In the discussions with the team, it is very clear to us that we have moved to tomorrow already. And as we have the discussions, we are challenging ourselves. How are we looking at how we are working on tomorrow? I'd like to really encourage you, Honorable Wanjala, that as long as anyone informs you they are part of the Wasilianahub network, just as you have had Mediator Sela, who's all the way from Eldoret, that they are switched on. They're already focused on tomorrow, because we did not start tomorrow now. We started tomorrow a long time ago. Why do I say this? The discussions we are having in this season and the ones that we have kicked off in this year have been focused on the Strategy 2020. And our Strategy 2020, which started off from December of last year, enabled us to focus on a number of areas which are to support us to give mediators the opportunity to specialize. Family wealth mediation is an area that we are clear that as mediators, we are committed to ensure that succession is a success in Kenya. And we kicked off even our executive program to be, which includes understanding of how families can share wealth, how they can hold it. And we already kicked off with our professional, Wanjiro Ndwati, who is an advocate and a certified trust and estate planner. The reason we kicked off this program is because We are clear that yes, in as much as we have done the first line mediation course, there are other areas that can enable us to be better and more useful advisors, and also be able to engage people who are advisors to families, whether they are accountants, whether they are the legal practitioners, and for us to be able to understand, even when the discussions are going on, how we can understand them better. So these are course that is already kicked off with, as I said earlier, Wanjala Ndwati, who's a certified trust and estate planner. We designed and started this program off in last year, early in last year, and kicked it off this year after doing our tests and trials to understand how society is. As I say this, I would like to highlight that our strategy 2020 has 7 core pillars, which are the ones that we are working on within this first half of the year. Family wealth mediation. Number 2 is financial industry dispute resolution. Number 3 is commercial and agri sector dispute resolution. Number 4 is extractive industry, which today morning we had a masterclass on mining to help us understand how mining works. And the masterclass is actually our 3rd lesson. We are still going on together with our facilitator, who is a mining engineer. The next one that we have is the sector that is coming up in Kenya, which is the creatives industry and sports and entertainment. Then further to that, we now have the labor relations, which today morning we also had a great session going through with senior mediator Gladys Wamaitha, and also with mediator Susan Mendot on the Employment Act and also issues of labor relations. And the other number 7 is on the education sector, stakeholder relations. Today morning we had a session with the innovations director of Longhorn Publishers and mediator Christina, who's been in the education sector for 25 years. And just to enlighten members that yes, Christina is actually on the last leg of concluding on a book on 7 competencies for or 7 habits for conflict competent schools. I highlight that basically on what the work Christina is doing, mediator Christina is doing, because we come from different sectors, and it is time we look at how we can add value towards how those sectors can actually be more conflict competent. So tie in your mediation practice together with your 25 years, your 5 years or 15 years, whatever area you're in. If you're a legal practitioner, if you're a doctor, tie that in, and now please let us know as Wasilianahub how we can help you. We are working with Christina to make sure that she's able to put out the guide and put out the book, plus also a risk assessment. And that is actually what now Honorable Wanjala, someone like mediator Christina, has been busy doing during this semi-lockdown period, even as we continue to, with the discussions. So those are our 7 core sectors, and we are delighted that you have joined us today, because you've actually spoken to us on one of the very major areas that we are committed that in Kenya we will support on how we can make sure that succession is a success in this country. In getting to the closing, I would also like to highlight that young mediators form a major part that we all must think about. During this period, yes, we have been able to be very virtual and very in the virtual space and very digital through a support from our young mediators. Mediator Amanda Maseno, mediator Rashid Buiza, who's been one of our moderators on the mining session today, and also other sessions we've held. Mediator Lily Maina, who's managing our social media even from today and repertorying. Young mediator Mohammed Saeed, young mediator Constance Terry. They have really stepped us up. Why I say that is because this is a terrain that they do understand much more easily as compared to many of the mediators. And really, I think the combination of the two, like earlier today, we had young mediator Rashid Buiza and senior mediator Gladys Wamaitha, and also mediator Susan Mendot in a session. I think it's our responsibility to see how we can bring the two ends together and then work, use those synergies. So as I've said again, Honorable Wanjala, if anyone comes to you and they inform you that they're part of the Wasilianahub network, be sure that they are sharpened, polished, and ready to deliver. So it's a delight to have you on this call, and I really, really thank you, and may God bless you. So ladies and gentlemen, we shall unmute, and you have the national anthem on the chat. Secondly, we have posted information on the Association of Women in Extractives in Kenya, that is AWEC, and that's where we are going for our virtual cocktail today. They are running a session on today, and which is an interesting area for us to also keep expanding our insight, our knowledge on. Please join in the session so that we can also just expand our knowledge beyond what we know. If you are conversant with your mother's tongue or your mother tongue, your vernacular, we're inviting you. In July, we kick off vernacular public mediation clinics, where we will be running on Zoom plus other channels and inviting the public. Mediator Sela has already volunteered. She's very conversant in her mother tongue, and Reed Kamunge, and also several others. So please help us so that we can be able to touch every corner of Kenya with the mother tongue. Thank you very much, ladies and gentlemen. So I invite you. We have the national anthem, the second stanza, which is in your chat. So ladies and gentlemen, kindly let us join together for the national anthem. Kenindu tufanye nasi tujitue nchi yetu ya Kenya tunayoipenda, Have a blessed night, and let's meet you at the virtual cocktail party. I hope this means that Honorable Wanjala has accepted that once the COVID situation has cooled down, you'll host us for a real cocktail party, Honorable Wanjala. Please say yes. We take that to be a yes. Ladies and gentlemen, have a good night, and it's been a pleasure. God bless you. Thank you very much.
Bless you too.
Yeah, God bless you. Bye-bye.
Okay, bye.
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 Have a good evening, all.
It shall be. God bless you.
Thank you. Thank you so much.
Wait, Sarah.
Yes.
A question.